Welcome back to Economic Outlook. Today I'm going to discuss the ramifications of the recent Chrysler bankruptcy. I'm not going to go through the failures of Chrysler as a company because these are already well publicized and everyone knows what's happening with US auto manufacturers. What I'm going to do is look at the Chrysler bankruptcy both from a public policy standpoint for the Obama administration and as a test of American bankruptcy precedent. On April 30th, Chrysler became the first of the big three American auto manufacturers to file for bankruptcy. For several months, the company tried to stay afloat on government loans and deeply discounted vehicles. Unfortunately, this wasn't enough, and the company announced its plans to file for bankruptcy and merge with automaker Fiat. The company hopes the bankruptcy proceedings can be completed in as few as 30 days. The decision to file for Chapter 11 came with heavy government support. The Obama administration has pledged over $8 billion in additional aid to the company. Additionally, the government has promised to help Chrysler back warranties sold for its vehicles. This is important because the government wants a quick turnaround for Chrysler, and if warranties are in question, consumers will be hesitant to buy new cars. With the government backing warranties, officials hope that Chrysler will have as little operational disruption as possible. Additionally, as a result of the merger, the UAW will receive a 55% stake in the new Chrysler Corporation. Also, GMAC will become the sole finance provider for many Chrysler dealerships. Few people argue that Chrysler would have been able to stave off bankruptcy had it continued running its business as usual. However, there are considerable questions about whether or not the merger with Fiat will produce a company any more capable of competing with foreign manufacturers than the old Chrysler. However, even more than these concerns, observers wonder about the role of the federal government in the bankruptcy process. Specifically, some people wonder if bankruptcy precedent has been broken by the Obama administration taking a more activist role in developing the Chrysler bankruptcy policy. Next, we'll examine exactly what the federal government has done, and then we'll look at whether or not this has helped shape the bankruptcy proceedings. From the beginning, the federal government has played a large role in structuring the Chrysler bankruptcy. The administration promised $3.5 billion in funding to help Chrysler keep its operations running during bankruptcy proceedings. Additionally, the federal government has offered another $4.5 billion after the deal with Fiat closes. This is in addition to $4.5 billion that was already given to Chrysler in the George W. Bush bailouts in December, and this is $2 million more than President Obama initially said he would give to Chrysler if they declared bankruptcy. On April 30th, President Obama addressed the Chrysler bankruptcy directly. In a speech, he said, "This is an American company that has a particular claim on our American identity. It's a company founded in the early years of the American automobile industry, a company that helped make the 20th century an American century, and that came to embody, along with the other two members of the Big Three, the ingenuity, the industriousness, and the indomitable spirit of the American people." President Obama went on to discuss Chrysler's role in our industrial economy and announced the merger with Fiat, claiming that it would save over 30,000 jobs at Chrysler and tens of thousands of other jobs with suppliers, dealers, and businesses. A key feature of the president's bankruptcy proposal is a drastic reduction in debt held by various financial institutions. The total amount of debt Chrysler owes is $6.8 billion, and 70% of this debt is held by four major banks: Citigroup, J.P. Morgan, Goldman Sachs, and Morgan Stanley. The Treasury Department has announced that these four banks have agreed to settle their portion of the debt for $2 billion, not the $6.8 billion that they are owed. Almost immediately after the Treasury Department's announcement, a group of 20 hedge funds and distressed debt funds emerged and voiced their displeasure at the government's deal with the major banks. These companies argued that in a typical Chapter 11 bankruptcy, first lien secured debt holders are paid before other companies receive money in the event of a bankruptcy. These companies argued that they were entitled to a greater portion of money than the large banks had settled for. We'll examine whether or not this has established bankruptcy precedent and look at the role the administration played in shaping the agreement with the large banks and see if the claims of these smaller institutions have merit. Let's examine why these lenders feel shortchanged by the agreement reached between the government and the four major banks. First lien secured debt holders are typically the first people to receive payment in a bankruptcy proceeding. This happens because the debt is collateralized by specific assets within a firm. Let's use a simple example. When a bank makes a car loan to a consumer, it knows that the car is a tangible asset that backs the loan. If the consumer can't make his payments, the bank can always repossess the car and sell it on the open market to recoup the money it loaned to the consumer. The same thing happened with these lenders to Chrysler. The loans they made were collateralized by specific assets within the company. In the case of Chrysler, the four major banks settled with the company out of court before the bankruptcy proceedings took place. The smaller companies were disappointed when the bankruptcy courts appeared to accept an agreement that favored junior creditors over senior secured lenders. In the government's bankruptcy deal, senior secured debt holders appear to lose out more than some junior debt holders. The UAW will receive a 55% stake in the new Chrysler company. It will also receive a union retiree healthcare fund and payments into a pension fund. The major banks, as well as the other senior secured lenders I've been discussing, will receive a payment of about 28 cents on the dollar of debt they're owed. In a typical bankruptcy proceeding, senior debt holders would receive full payment of their debt before junior debt holders, and this is what has angered some of the smaller lenders that were not a part of the government deal brokered with the four large banks. On the surface, the bankruptcy proceedings appear to favor junior creditors over senior debt holders. This has prompted a severe backlash from people in the financial industry. Curtis Ulrich, co-head of U.S. fixed income at BlackRock, said, "Given that so much of total borrowing across all asset classes is first lien in nature, the damage that would occur to the economy as a result of higher first lien borrowing costs resulting from lenders requiring a higher return to compensate them for an unknown interpretation of claim priorities could be substantial. Many lenders make loans by being investors in U.S. financial markets where contract law has been sacrosanct, and deviation from that could have far-reaching implications for the U.S. economy." Jeff Manning, a managing director specializing in bankruptcy and restructuring at Trinwith Securities, echoed these sentiments, saying, "People are pretty comfortable with the bankruptcy rules. What they are trying to do in the Chrysler situation is unprecedented. This isn't the way the game is supposed to be played." These commentators and the small lenders that we're discussing argue that the possibility for government intervention in bankruptcy proceedings, which overrule the rights of first lien secured debt, will increase the cost of that debt in the future. This could have a ripple effect through the already strained credit markets we see today. Some of these observers have gone so far as to say the government is pressuring banks which accepted TARP funds to behave in a certain way. In our next entry, we'll look at whether or not this is the correct interpretation of the bankruptcy code.